compilation is ready, my lord. I am giving to.
May I have your
Yesterday,
lordship's
my lord, we
kind-
have received a copy of the
kind
compilation.
brief to
My lord, I was opposing the other prayer, my lord.
May I have your lordship's kindly to mention with regard to item number 9 from today's list, Lord. On 6 last, your lordship were pleased to extend the interim order up to 18. So, Lord, so if it is not taken up today, then may I request
Let
your
us
lordship-
see. Let us see. 9 is fairly at the top. Yes.
Yes.
Then
Upon notice, my lord, I am mentioning, my lord, one matrimonial hearing of 2005,
Hearing, just
my
wait.
lord.
Just wait, madam, for some time. Let us dispose of some of the matters, then we'll take up. Don't worry.
Both are senior citizens.
Yes.
May I, your lordship's kind leave, your lordship mention, your lordship. I'm praying for a leave to file a cross objection, your lordship, without certified copy.
Not necessary under the appellate side rules.
Well, I'll go and file it, your lordship.
Please look at the appellate side rules. What are the procedures? You know better.
My lord, may I permitted to mention, my lord, the bench was coordinating on 14/12/2023. The matter is that that the coordinating bench was sitting with Lordship and Justice Rai Chattopadhyay.
I could not understand what you say, madam.
My lord, the coordinating bench is sitting with
Coordinate bench,
yes, my lord.
not coordinating bench. Coordinate bench.
Coordinate bench sitting with Lordships and Justice Rai Chattopadhyay that on 14/12/2023. And that
What do you want?
my lord, the affidavit has been exchanged. There is a direction of exchanging of affidavit.
But we never sat here. That must be an Andaman matter. She was there in Andaman. First ascertain whether it is to be mentioned here or not.
Like extension of interim order and application in connection with first application.
Okay.
And one application for review, your lordship was decided about sitting with Honorable Justice Obijit Gangopaধ্যায়. I got decree. I am plaintiff landlord. I also got decree for through special official appointed by this honorable court, but they took out an application for review that is pending. I want to discuss. I'm giving to a lordship.
Okay. Huh? For orders. আজকে থাকুক তারপর দেখি বা ডেকে নাও চল ঠিক আছে next
My appeal. 6 down.
what is this?
Third time for the appeal and ballot. The suit was under section 5, 31, 34 and 38 of the specific legal. The suit under section 31, cancellation of deed, Milord, as against defendant number 1 to 3.
Why it is appearing as for orders?
Milord is, it was arguing the matter.
Is an FMET against which order?
Is an order passed by Milord.
Not passed by. Against
No.
which order means injunction or what?
Injunction order, order was refused against
Ad
the
interim,
prefer.
ad interim refused.
Ad interim refused.
Yes, what do you say?
Milord, Lordship directed to file the list of dates. Well, the fact of the matter is, Milord, in 1943, one Khusiwala Dasi was the owner. She bought
Just objectives.
লিস্ট অফ ডেটটা দিয়েছে, হ্যাঁ লিস্ট অফ ডেটটা দিয়েছে।
আচ্ছা ঠিক আছে তুই একটা কপি দিয়েছিস
হ্যাঁ কপিটা দিয়েছি, লিস্ট অফ ডেট।
মজা নিচ্ছে মনে হচ্ছে।
Could you comprehend what the learned judge want to say?
That in the initial date I could not.
I have also failed to understand.
My learned pen will assist my.
Actually, I wanted because the facts are so distorted, the grammatical mistakes are so.
Some other matters it has been inbuilt here. No, no, my lord is asking. You can comprehend the order.
I do not know what the learned judge want to say by this order. How the title lost, how it is done. I am unable to understand I am a very bad in English language. Very bad.
My lord is laughing. My lord is a newcomer. He is laughing when you have said that I am very
Very bad, so I could not.
very bad in English. You see, Postal is also laughing.
Of the trial judges and no etiquette as the lordships are, my lord. That is the.
Are ki dilo?
Tell you, lordship, my lord, what happened.
Let us see what.
Kindly, I find, my lord, this is absolute
Just one
title
minute.
dispute.
Just 1 minute. List of dates.
আগে দেওয়া হচ্ছে।
সেটা দেওয়া
হ্যাঁ হ্যাঁ আগে দেওয়া হয়েছিল। বাকি দিচ্ছে 59 এ, আমাদের কাছে 51 এ নেব, বিক্রি 62 62 টাইটেল ছাড়া বিক্রি করা যায়। লিস্ট অফ ডেট দেখছিস? লিস্ট অফ ডেট দেখছিস? হ্যাঁ সরি না
We have also prepared a, my lord, list of dates to be lordship.
সরালি না, সরা নাই কাজটা।
Oh, this is a case of impersonation.
Yes.
Many things. But let us see the list of dates. Now, I will place two more documents for your lordship consideration. Probably that is in your with your lordship. This is, my lord, title of the plaintiff. This is the title of the defendant claiming. Whether in this case there should be status quo. This is the only question to. Everything, my lord, is totally in title dispute. Law, impersonification, forged document, all are there. Well, that document is with my lord, my lord. It's 2 pages document, 2 pages each.
Where?
That is copy আছে দিতে না
কপি আসলে
এইরকম দুটো কপি দেখতে
আচ্ছা
So এইভাবে রাখা হয়, একটু ছোট করো। এটা ছোট করো।
থাকবে না তুই রাখ না ওখানে আছে
সব আমার দিকে চলে আসছে। This is a document you want to
2
refer.
pages. Yes, yes. Kali, first of all, but Kali take the plaintiff case.
Yes.
In a nutshell, we have stated, my lord, how the plaintiff's title devolved. Justice Postal Kali got it, my lord. My lord, Justice Postal got it.
So the same thing you have reflected here.
But differently, I said how they claiming the title
No, that it appears to me that
in the list of dates. Yes.
initially the property was with Kushibala.
Yes.
Then Kushibala sold a portion thereof to Meena Saha.
Right.
Yes.
The Meena Saha,
See the dates.
no, that is in 59 and 43. I have seen that. Then the Meena Saha was dealing with the properties.
My lord.
Then suddenly somebody showed that the Meena Saha is dead.
Yes.
Then the Meena Saha made a complaint,
Yes.
and during that
In the
I think
military property
currency
transfer.
of that she died.
Yes.
Now a claim is made that the Meera Saha has already sold the property to
Property.
the plaintiff.
When she was alive.
The
To them. When she was alive. And another person
Then
is
you
there.
say
my lord.
that Meena Saha never sold it, impersonating somebody.
Yes. This
Somebody
is our case.
impersonating that she is a Meena Saha sold it.
And another
This is
person
what
case,
your
my
case
lord,
is.
as my sister, we never know.
But
You know what?
as my sister, which never ever know.
Yes, yes, properly. I have written my lord the entire thing. Can you see the two documents I have handed over to my lord? How the property is devolving.
The defendant's document.
Can you see the defendant document first?
Defendant's statement.
My title deed has been annexed with my evidence.
Then I'm showing you. That's so.
By a Bengali Kobala dated 15 June 1943, registered on 16 July
No,
1943.
that is what is the plaintiff. You are claiming.
Yes.
We got it
This is
from this
defendant.
also.
This is not plaintiff. This is defendant document. How they are claiming.
No. This you are referring title of the plaintiff or title of the defendant.
Defendant I am showing.
Yes, sure. So Kushibala 43 admitted.
43 admitted.
Then
Then
now
Kushibala sold
question
the
is
land.
that she sold it to many persons.
Or can you see next page? Your lordship will get the deeds.
Four persons in
Yes.
62.
My
Then
lord.
Sulota, Dipti, Usha, and Kanti Bhushan.
Now we can sell.
Now, my lord, kindly go to the list of dates. Can you see the dates? 59 he sold to us. List of
Oh.
dates can you see?
59 Kushibala
Yes.
sold to Meena.
Yes, sir. Now Kushibala is selling.
Now
62.
Kusibala is selling
In 62.
in 1962 to my Mr. Ghosh's client.
No.
Yes, this is the
That is
Now, sir, this appears to be that the total area was 245.33 shatak of land
yes,
owned by Kushibala.
yes,
She sold 2 acres 45 shatak to Meena.
yes.
Now, I do not know the mathematical calculation between this. Now, how many shatak makes acre? I do not know. And then she sold 2 acres.
They are claiming 54 kathas of land regarding.
She had 130.
59. সেল করে দেওয়ার পর 62 কি করে সেল করে
Which is 1/3, 7, 1/3, 1. It's 1/3. That 1/3 is sold out of 1/3.
Their claim is they are getting from Kusibala in 62. Their claim they are getting property from Kusibala in 1962 and 59 sold to us.
No, I got you.
Yes, that's all.
That is what I understand. Now, did you produce the document of 59?
Yes.
Did you produce the 59 deed?
No,
Yeah, this is here.
Xerox copy of the title deed.
Have patience. When we are asking a question, have patience.
It's 80 to 90.
Did
Well,
you
can you
produce
see-
this
can you see the list?
1959 deed?
Kindly see the list of dates.
No, I am asking at
Yes,
page
page 80.
80. Show us page 80 of the stay application.
Certified copy. Type.
Well, to get the both the certified copy and the type copy both.
The document.
And both are difficult for my lord.
It's side. Oh, this one. So the notings of distribution.
1962, Kushibala did not have a title to sell.
What are you saying? There's the
80,
page
my lord.
89 is a typed one. I do not know. Bengali
Yeah.
Kobala does not start in this fashion. What are you saying?
Page 89, my
Start-
laptop.
It starts with Bikroy, Kobala,
Yes.
Thana, Jadavpur, Mauja,
Yes.
Madurdoh.
Yes.
Then what is this? There must be something. Kreta, Vikreta, something is there.
Kindly go on their style of drafting. Kindly go on.
Arey, there must be a reflection of a Kreta and
Yes,
Vikreta
that is there.
first.
That is there.
No.
Can you read it?
No,
Yes.
But
Sabe-
it may come in the recital.
Kobala Grohita.
Who is a
Kobala
Kobala
Grohita is Meena Saha.
Kohita?
Kobala Grohita is Meena Saha.
Kobala Gohita did. Kobala Data Smriti Kuchiwala Dasi.
This is the seller, this is the
Bengali
purchaser.
from Gohita
And
থেকে
then
আপনারা
the deed comes. Even in Bengali deed, is a Kreta, Vikreta.
The may not be. May not be always.
And then it comes.
in English এ Smriti Kuchiwala Dasi, but he is mentioned in 4.8.
কষ্ট করে ফেলেছিস। This is a registered document, there's a type copy. So he has a presumptive value.
Yes,
So both are there.
I have seen that Grohitri, Minasaha, Sami, such
Rohita,
and such.
all are there.
Not Grohita, Grohitri, not Grohita. Grohita.
Gender is different.
Absolutely.
Properly drafted. So my lord, all ingredients are there. And if it is being doubted, my lord, it requires an adjudication.
श्रीमती खुशी वाला स्वामी काल हनी कानू बोली number 49 145 number Toji Buttu Jela 7.66 শতক 7.66 শতক খরিদ বার্ষিক খাজনা নিগত জমিদার যত অতীন্দ্রনাথ দাস বিম্ব শ্রী জটিরা ফর্দ ফর্দ খুশিবালা দাসী ও কার্তিক চন্দ্র পাইক নস্কর মহাশয়ের আমার ও প্রকল্প পরিচালনা সিরিয়ালটা অংশ
But we'll get the schedule at page 91. Schedule is there.
শরীরগণ যাহারা উক্ত জমির 1/3 অংশের মালিক ছিল তাহাদের সীমানা নির্ধারণ করিয়া হস্তান্তর করিয়াছেন জ্যোতিরাম নস্কর তাহার 1/3 অংশ 2.45 শতাংশ
concurrent view হয়েছে
হারাহারি খাজনা 4/3 ये बड़ा मुश्किल चार आना होगा और 12 कितना पाई জমিদারের স্বেচ্ছায় আদায় দিয়া প্রজা দক্ষিণ সত্য সরসওয়ার মতো করতে তাহার অবস্থায় তাহার নিজেও 100 আমরা 3 চিহ্নিত করবো অফিসে সচেতন লিখতে Obala, yes. 2.66.
Hmm.
And, 1.3. And with the demarcation. Yes.
My lord, see in the Chaudhary also at page 91. 9 lines from top. After iti, date of execution, then
Where? Iti.
iti, my lord, got a 9th line from top, page 91, internal page 3.
9 from top. স্বেচ্ছা সম্পাদন করিয়ে দিলাম। হ্যাঁ,
ইতি।
1365 সালে।
65 সালে ফাল্গুন 17 February
ফাল্গুন।
1959.
Right, read full. 5ই ফাগুন। Then ইংরেজি 17/2/1959
Yes.
সালে
খুশিবালা দাস
পঞ্চম ফর্দ that you have to
sign. Then my lord, kindly বিকৃত জমির তফসিল, that's the schedule.
বিকৃত জমি
জমির
তফসিল
তফসিল
পরিচয়
জেলা 24 পরগনা, থানা যাদবপুর, রেজিস্ট্রি অফিস আলিপুর, সাজান মৌজা সাজান হাল খতিয়ান নম্বর
খতিয়ানভুক্ত
2.45 শতক জমির বার্ষিক খাজনা।
read how many
এবং
what is বার্ষিক খাজনা?
the revenue of the yearly revenue,
What is the revenue?
চারানা
চারানা
at that point of time
and how much fine?
টাকা আনা পাই ভুলে গেছি, এখন জিজ্ঞেস করো না। that খতিয়ান নম্বর 14, RS দাগ নম্বর 414 415, খতিয়ান নম্বর 4 414, দাগ নম্বর 4 14 নম্বর দাগে বিলি জমি সাথে ইন্টার চৌধুরী has been given.
That is what he has said, that initially that the Jomindar Mahashoy Atindranath Das উনি তখন 3 peoples he sold, and then later on he demarcated all
among
these
themselves.
shares amongst themselves. That we have got.
That I know, my lord, you were reading, I understand, everything is before my lord. So now question is whether the 59 deed I have produced before the court and a registered deed.
Did you produce the court? Because the court did not.
This is the stage for production original. I am learning from Mr. Ghosh now. Yes, let it be produced on evidence, not at this stage. Yes, my lord, kindly pass an interim order. It's a forced document, so it requires a trial. 83 Supreme Court.
Suit was filed when?
Suit was filed 23. My lord is off-quoting judgment, 83 Supreme Court. Rely on that.
And what was the mutation? The property is mutated in whose name? Is it Kushibala or it is in the name of Mina?
I'm just showing to lordship. Mina. Probably Mina. Let me check up. Page. Particular mutation has been
93.
page 93, 94. I know this will be my lord's query for a privacy title.
When granted? 98.
93.
93.
This is 98.
No, 93.
Probably it is 93.
Read Malad is written 1990.
What are you saying? 98.
Maybe. I am not disputing now. Next page
The
is
dates are there. 1911, 1998. Then reference number 64 of 98.
98. Page 93.
page 93 and 98. It's
Nine- Yes,
90.
that is what I'm saying.
90.
Classification is a bill.
Next is my lord, Khajna.
Yes.
Imba Minasa.
Kiminasa.
PLRO,
And this khazna is of
And
which
this is
year?
the sketch map attached to the mutation.
Khazna is of which year?
Khajna.
Not ready. Must be after. It is after 1998 document.
Yes, yes. Must be after 90.
Has to be.
Has to be. Otherwise, it cannot be. Then, my lord, if you lordship turned out, your lordship will find 95 is a sketch map prepared by the BLR.
Yes.
It of course.
What is this?
Everything forged.
What is this?
95.
Yes.
A sketch map
Yes.
of 2000. Yes, it is of 2012.
Yes. What is this reference?
Is my property.
Oh no, sir.
My
The
enter property.
question is very small. Question is that you are banking upon a document of title executed and registered in 1959. That's all. Now they are banking upon a document
62.
of 62 saying that the
And there
original,
is forged one.
original owner Khushibala has sold those properties to them. Now they are assailing or they are asserting that this document of 1959 is a forged document.
Scope has not come. They have not appeared in the court.
I'm saying. Now you have produced this document, which is the certified copy of the deed, purported deed obtained from a registration office.
Obviously.
Now, on this score, you said that you are in possession, as I find, which could understand from the impugned order.
This is the matter.
Could understand from the impugned order is that you claim that you are in possession. And there is certain deeds. I believe that 62 deed you want to assail or what?
Yes.
I'll come in there.
You want to assail 62 deeds?
Now it is not disclosed, so you have to amend the.
I do not know.
I have
It's
to.
because the order says some deeds are under challenge or something like that.
Nowhere. That is the main. Kindly go back.
That is what I am saying, because at ex parte stage,
Order impugned, my lord cannot make out of head and tail out of that.
can you show me the plaint?
Yes.
You have given it a plaint. You have given a plaint.
Pledge 145.
This is the plaint.
145. No, this is not the plate.
718 Uday Kumar.
That is something else they have produced.
Okay. Anyhow.
145 is the plane.
145.
45.
Start from 145.
145 is the plaint. Correct. And what are the reliefs? Relief as play as
Relief
at page number?
I just see the reliefs claim.
Yes.
Where is the
164.
164? Declaration of title. Negative declaration. Now, this is what I really wanted. The conveyance executed. This is of 2021.
No, this is something else.
Defendant number 1 and 2.
Defendant number 1 and 2 is
Yes.
void.
There appeared as ground order.
And then
Now this document now surfaced.
now, this is the document, this deed of conveyance of 21. That is this defendant number 1
1 and 2.
who sold the defendant number 1 and 2.
False Minasa.
That so-called false Minasaha.
Defendant number 3.
So this is what you wanted to
Yes.
say. And they
Now
are
it has been
they
surfaced
are
now.
a defendant number 1 and 2.
4 and 5.
They are 4 and
4
They
and
are
5.
4 and 5. Now this has been surfaced now.
amended.
This document. Now we have to amend it.
Yes.
I have to show to you prima facie what documents we have to sustain at least prima facie that I have a title. That's why, my lord, I have put the deed, the mutation certificate I have annexed, and we have also said, my lord, the Minasa, when she was alive, she made a complaint.
Where is that complaint?
That complaint is page 98. 98 তখন দেখা লাগবে। Yes. Kindly come to page 98.
Defendant number 1 and 2.
Oh, this is Meena Begum. Some Begum has come.
Yes.
Defendant number 3. One day appeared, certified for
I have got a false certificate, death certificate of mine.
I have.
Yes.
So she has obtained the false certificate of herself.
No, I have got a false certificate.
What does it
Means
mean?
that certificate used that I am deaf. That has been annexed.
No.
Enclosed kindly come.
I can understand. I come across with the false certificate.
That
I have
language, my lord. Kindly see.
I have got. So I just thought that
And-
she procured it.
When it was executed, she came to learn one death certificate issued in her name. That's why she has annexed while complaining to the police. That see, this is my death certificate.
What the police did about it?
Nothing as usual.
What is the date of this letter?
Letter is, my lord.
The minus signs here as difference. Now, the document she says has been executed by.
Something it is a post murder date must be there. The data the পাওয়া যাচ্ছে না। Oh, 20th July 2017. 19. This is not a subsequent document. We also made a paper publication. Can you turn over? Or kindly turn over the page. This cannot be said after thought. Can you turn over the page? Module 5, though this is the vernacular. Paper insertion.
Disclaimer.
The false. And now two false death certificates. One false, one's original. Kali turnover 100 issued in 2015
Yes.
and original is
She
101.
died on 9/9/2015.
Yes.
And the second one?
Second one is next page.
Real.
May 2021. Really, my mother died. All the certificates. Eight হচ্ছে 32. Now, my brother, kindly keep in Lordship's mind page 101. It is May 2021. My mother's original death. Kindly come to 32. Page 32.
For what?
This is the deed which I have challenged, executed in July 2021.
This is specific. Death of the local area of
Page,
32.
yes.
This is the deed which I have challenged in the suit, executed on July 2021
Oh, by Meena Saha herself.
by Meena Saha, who actually died on May 2021. মুসলমান করে দিলি আমাকে
of the same matter.
ফর্মালিটি কি মামু
Whose deed is this?
Given 1 and 2.
1 and 2, which I have challenged in the suit.
And 1 and 2, 1 and 2,
Now, this deed now been surfaced. I will challenge it.
no. And what about 4 and 5?
I'll challenge.
Now, this is surfaced now. I have to challenge that. Who has no title?
No, no, 1 and 2 again sold it to 4 and 5.
No, 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 no.
It says 54 cut. Yeah, there is the
You know,
54.
50 total হচ্ছে 54 কাটা 54 কাটা land, entire land belongs to Kusi to Meena.
They are now claiming 20 cutters. 4 and 5.
They are now claiming part of that. Whether why not consider whether Meena Saha has right on that date?
Sir, two things that comes. You are claiming here now what I gather is, please correct me. Both of you who are contesting one, the defendant number 4 and 5 and the plaintiffs, they are all tracing their title from Meena.
Meena.
Both.
Yes, yes.
You are not Sanjay Biswas.
No, not Sanjay.
Who are you?
Hello, we have the transferred it from the original bank.
Right.
No, you are not Sanjay Biswas.
No.
Oh.
No, no.
So this is the deed. This is the deed they wanted to assail.
Yes.
Sanjay Biswas is defendant number 1 and 2.
Dependent on one end.
So why 4 and 5 are made party?
Because they have purchased the same land which I have purchased after my deed.
But you did not challenge that particular 62 deed now. If they claim.
Challenge the recovery.
This deed now surface was not known to us. How can I challenge it? I'm asking the question to myself. It was not known to me. It was never known to us. I might have seen the game. A person who was making dead, got it executed.
I understand. Then why you are pouncing upon the 4 and 5?
Because my land,
20 cutter land.
this is my land.
4 and 5. When
4
you
and 5
implicated them
purchase-
a party, then what was the allegation against 4 and 5?
Just a minute, I'm showing to you.
I just wanted to know what is the allegation
Can you come
against
to the-
4 and
come-
5.
can you come to the plane.
Opposition manner, secretly claiming title to this property, the either suit has been dismissed. These are
Me,
Yeah,
again
yeah,
that
let us see,
Meena
let us see,
Saha, again that
yes.
Meena Saha.
Let us see where
Just a minute.
what you have said about 4 and 5. I just wanted to know against them. Why you have implemented them a party? Your main grievance is against defendant number 1 and 2.
Yes,
Sanjay.
That, my lord, I repeat. In the
Okay.
meantime, I am showing to lordship. I repeat, land is one.
Paragraph 4.
Yes.
16. 16.
So you are making them a party because of their name is appearing in the record of right.
Then possession.
Possession also.
Recovery
My lord,
possession.
kindly come.
So they are in possession.
Yes.
No difficult.
Recovery possession.
No difficult. Let us hear.
I have no problem hearing him. I want to submit before lordship. But this
Then
is the
what
land
injunction you want?
status quo.
What status quo?
Both the parties will be restrained from doing anything.
Both the parties, why you have nothing to do?
I have. This is
You
my
are
land.
you are not in possession.
And possession. 23 cutters.
My lord,
You are not in
total-
possession.
my lord, kindly
Then what more?
total land 54 cutters.
20 cutters.
Am I clear to my lord? 54 cutters total land. This 54 cutters land purchased by my client from
Mr. Basu, I should not remind you of the judgment of the Supreme Court that at the injunction stage, there is a distinction between a prima facie case and a prima facie title.
I am saying privacy case. I have not gone to the title.
So you are really banking upon a prima facie title. Now question is 54
54
decimal
katta
of,
land total
yes, kathas of land is a subject matter of dispute.
purchased by me in
Now,
1959.
sir, that is what there. You claim that you have purchased it from 1950,
I've
in
sold it.
1959, your mother, predecessor.
My lord.
Correct. You say that you are the owner of the property by virtue of devolution from your mother.
Yes.
They in the meantime says, no, Meena Bala did not acquire any title. Actually, this property was sold by Kushiwala sometimes in 1962, if I correctly understood
yes,
without
yes.
hearing him.
Yes.
And they say that they are all along in the possession of the property and they are enjoying that particular property of 54 katas. Or maybe more. I do not know what they claim. In the meantime, 1921 deed came where the Meena appears to have divested her title. You say that this deed came at the point of time when Meena was dead. So somebody impersonating herself as Meena has executed this document. So you have sought for a cancellation of this document. Now question is that title is one thing, possession is another. And now for the purpose of bringing, some kind of a, that further encumbrances or something,
asking
the
for.
one has to. Status quo has a very dangerous concept.
Kindly make it as
No.
in the manner lordship can pass it. My lord,
Let us hear him.
no, hear him. My lord, let me. I just remind your lordship, my lord. 83 Supreme Court. 83 Supreme Court. I am
This is
reminding.
what I reminded you.
I know that this is we are in the same school.
Daulat Ram's case.
Daulat Ram will say that if there is a really dispute of title, that creates a prima facie case.
Anyhow, let us.
Then, my lord, kindly come to page 154. The plain my lord is asking for. What is the allegation?
So now I have seen paragraph 4.
No, 7. Kindly come to 7.
7, 8, 9, 10 against this one model 4 and 5.
Yes.
We object to them. Now it surfaced that he has a title. They has a title. So I have to challenge that. It was never surfaced that they have title in the property.
Yes.
That's why my humble submission, my lord, that status quo in the form my lord decide. Now come to the impugned order once.
Let us. I have gone through many times, could not understand head and tail, could not make out. Anyhow, let us hear him. 4 and 5.
I appear on behalf of the
Defendant number 4 and 5. The allegation is that you are making a boundary wall.
I tell you.
No, that's the allegation. I said, don't say no all the time. The allegation is that you have made constructed a boundary wall. That's allegation I have said.
Allegation. My lord, case made out by my client is that, my lord, initially 1962.
Now, what do you have to say about 1959 deed?
1959 deed, I say, my lord, this particular deed is not in existence in the conflict.
Not in existence?
Not in existence.
Have you obtained any kind of information from the
Yes.
registration office? Have you got that?
Yes.
Have you produced? Show us. That this document is not registered in the volume.
Interrupt. Your lordship has the power. Can you call for the volume? Everything will be clear.
Let us see what he says. Simpliciter saying that this document is non-existent document. I do not think so. Why have not annexed in your opposition?
I told my learned junior and my lord.
Told you.
देखी ना जानी नाम तो जानी
The dates are different, but on this regarding the same subject matter.
Untraceable. That does not mean non-existence. What are you talking about, Mr. Ghosh? No. It simply says that we cannot provide you an information as that particular volume is untraceable.
Untraceable, my lord.
Means volume, their original document is untraceable.
Call for the volume, or that if you lord, you can call
The
for
volume.
the volume. Now, my lord, I tell you, lord, my lord. And I tell you, lord, my lord.
The volume is not so lost the case. What I'm saying is the volume is not. So this is something that we got see in the sequence. But non-existence you can't say that it is not.
Just give me, my lord, 5 minutes, lordship's time, my lord. I tell you, lordship, my lord.
Lord could not. How can you say the non-existence?
The same cause of action, my lord. I tell you, lordship, my lord. I can give you 2 deeds, my lord, 10 katas of land, each 20 katas by 4 and 5. We have purchased from our vendors, my lord. We have
When? 1962.
No, 1962, I'll tell you, lordship, my lord, what happened. Initially, Jyotiram Sapui or Noskor was the owner.
Whatever, Jyotiram
Yeah.
sold it to Khusibala 1/3,
Okay.
not the entire. Out of
Not
7 acres, something,
Yes.
1/3 to Khusibala.
Now I tell you, lordship, what happened, my lord. Kuchiwala subdivided into 25 plots. The 25 plots to different purchasers, my lord. The different purchasers purchased the property, and thereafter, my vendors has given to us, given number 4 by Boloram Gupta.
Who is your vendor?
My vendor, my lord.
Khusibala,
Kuchiwala is not my vendor.
not vendor. So you have purchased from whom? From these 4 persons. 1962 deed holder. Have you?
We lost it. Please, I didn't interrupt. Kindly take my opposition, madam. Evidence opposition. I have given my title deed, madam. If you lost it, kindly come to my evidence opposition.
Arre,
But there is no reply to no reply has been given by my learned friend's hand, my lord. Therefore, they have accepted it.
Reply
you are unable to say, sir, we are now mugged up all the names. Tell us the names.
My lord,
From where? Who is your vendor?
my vendor is Jagannath Gupta, who purchased it from the initial Kushiwala.
Khusibala. That is what I wanted.
Yes.
And that Jagannath. Please. You are a veteran in a civil law. It is not expected that you will not say. So, this, your vendor, she purchased from Khusibala when 62, prior to 62,
2004.
she purchased from Khusibala in 2004.
From the subsequent purchaser who purchased from Kushiwala, we transferred to my client.
Oh,
Let me answer, my lord. I'll answer you later. Well, kindly it comes to page 22 once. Well, see, the deed of conveyance did date by Jagannath Gupta to
page
Uday Chandra, page 22 of my opposition.
page
Page
22.
22.
This is your deed of 2004. I am not saying so. I am talking about the deed of Jagannath.
Jagannath.
That will file at page 8 of that document.
Please do not. I am asking the deed of Jagannath. When Jagannath purchased from Khusibala, it's a 62, it's a prior to 1959, or when? I just wanted to know from you. You are talking something else. I was asking this.
I was
68. You page 30. So this is 1968 deed. Khusibala, vendor, and Srimati Usha Ganguly is the purchaser. And that was 1968.
Yes.
And then Usha Ganguly, she sold to Jagannath.
Jagannath Gupta.
Usha Ganguly was such and such. Then 1982, Usha Ganguly.
1998 to Abha.
He sold it to Avade,
Abha
Torabdar.
Yes.
That was in 1982. Then what Abha?
To Jagannath Gupta. 34.
That is 1998. This Avade. Now Jagannath. So that is very clear. So both of you are tracing title from Khushibala. That is what a common thread is. Your predecessor, your whatever, your vendor's predecessor, that vendor's predecessor, whatever, means the great-great-grandfather appears to be a Khushibala. They are also tracing title through Khushibala. Now the question is that Khushibala sold, if she has sold the property in 1959, and if the property remained the same property, then the question arises that whoever is a prior purchaser, he will have the title and not the subsequent purchasers. Now question is that they have produced a particular certified copy of the deed which was registered with the registry office. You say non-existent. So, but your document does not say non-existent. What the document says that I can't say whether it is an existence, I can't say whether it is non-existent, because they record that volume is untraceable. Volume is untraceable. And it is always under volume 1. Any sale deed is done. So he says that of that particular time, the volume is not traceable in my office.
Now it's not.
Now the question is, if the government of officials or office does not retain a particular volume, the official record which he is supposed to keep, does it mean that the transaction which was done will be all effaced, becomes illegal, void, everything?
My Lord, your Lordship, can you come to page?
Tell me, if prima facie it appears that there is, if you can show that this document is a false document, this document is a fabricated document, I can understand.
My Lord, this issue has.
Sorry, this issue is you are in possession, enjoy the possession, but you can't transfer the property to a third party.
Document, my Lord, I shall show. My Lord, one document. Kindly page 201. Kindly count.
This shows of your opposition.
Yes.
Yes. Oh, where is that? Show us. Then let's be
Page 201, my Lord. Page
200?
Page 186. 186. This particular Vinasha.
Yes.
186.
P7.
What?
P7.
181.
186. P7.
Yes.
My Lord, your Lordship had gone through the prayers in the plain filed by Aparna and Payal. Your Lordship had got it.
Aparna and Payal?
In the suit file.
Present suit.
Yes. Now, my Lord, your Lordship, I shall show first the plain. One.
That's a printed. Find a suit in 2011.
That Vinasa.
Against Amalesh. Who is this Amalesh Das? And another? Who is the another?
Amalesh Das, Mr. Ganguly, Sunata Mukherjee, they are the vendors of other properties. They have been implicated in this suit by Meena. And my clients, my vendor, Hotel Gulab and Sarotnath Mollik was implicated in the suit.
Your vendor is not Gulab.
Gulab, there are two vendors, Uday Chandra and Purnima Mollik Trust. My clients are two, they're 4 and 5. The fourth vendor was Jagannath Gupta, and this particular Sarotnath Mollik and Purnima Mollik purchased 10 kathas of land from
What are you talking about?
Jagannath Gupta. They are the owners of both the properties. They have transferred 10 kathas each in favor of different number 4 and different number 5. My clients were implicated. Your Lordship was found.
Huh?
Page 193. 173.
dismiss for default.
Now, my lord, can you see? This is a suit for cancellation of fraudulent deed, permanent injunction and declaration. In verbatim manner, copy paste the players in the application. This suit and this suit are the similar.
Which one? Where is a 3/1/19 2019 order? 3/1/2000. Page 198. The petition filed Hajira, plaintiff is absent without stay. None moves. Call for the plaintiff. The plaintiff is directed to show cause why the suit should not be.
They did it from paragraph 5 onwards. After the said purchase, Timothy Kuchibali Dasu was in possession and occupation.
Which one? Which one you are reading?
Page 175.
Is your mic on?
Yes, yes. Page 175, my lord, if you lordship kindly come, read from 5. These are the same statements made in the suit filed by opponent and pile. Now, my lord, your lordship kindly come from the prayer 180, paragraph 17. The plaintiff has become the absolute owner and having possession of the suit property by constructing boundary wall, paying land revenue. She is entitled to get decree or declaration, deed of conveyance illegally and fraudulently obtained by defendant number 1 and defendant number 3. And also in favor of defendant number 4 and defendant number 5 should be cancelled. And now I need to see the prayer 181, a decree of declaration that the deed of conveyance illegally and fraudulently obtained by defendant number 1 and defendant number 3 in the year such and such, executed by Kuchiwala Dashi in favor of defendant number 1 and 3, and also subsequent transfer made by defendant number 1 in favor of defendant number 2 and finally by defendant number 4 in favor of defendant number are liable to be cancelled. Now, my lord, in such a suit, my lord, application identity injunction was filed. Now, my lord, if we look it, something comes to the next page, 118, start from annexure 37186, the relevant portion is at 188. You not will find they could not substantiate the title in the property, identity was refused. I read, my lord, if you look it, kindly give me 2 minutes time. It is contended by the plaintiff that the plaintiff purchased the suit property in the year 1959 by virtue of a registered deed and has been peacefully occupying the same since after the purchase on about 31st August 2011. The plaintiff first time came to learn that persons are trying to trespass a portion of the suit property of the plaintiff and claimed that defendant number 5 purchased a portion of the suit property by registered deed. Thereafter, the plaintiff obtained the certified copy of the deed of conveyance by which the defendant number 1 purchased the suit property from Kuchiwala Dashi in year 1968. Plaintiff also came to learn that Kuchiwala Dashi sold out a portion of land to the defendant number 3, and thereafter the defendant number 3 sold the said plot to defendant number 4, and the defendant number 4 also sold the said portion to defendant number 5 on such and such, which is also the suit property, and the plaintiff, accordingly, the plaintiffs come before this court with a prayer for cancellation of fraudulent deed of conveyance. Plaintiff also paid for a temporary injunction, against defendants restraining their main and agents from interfering with the peaceful possession and occupation. And now, last, my lord, I see, my lord, I find no cogent ground to grant identity injunction at this stage. The player of plaintiffs accordingly refused. Page 201, the suit was dismissed for non-compliance of the court's order. This was default, it has not been restored. They want the same prayer made in the earlier suit, whether it operated as a res judicata in this suit. Because, my lord, I know, my lord, you lost your state because has not been disposed of, made it. But
No. It's a dismissal under Order 9, Rule 4.
Order 9, Rule 4. But in the
That's why I say. That's why I say it's not that.
It operates, my lord, because they have
No, Order 9, Rule 4 does not. It says does not prevent even a plaintiff to institute a fresh suit for the self-same cause of action. If he can, then whether the Section 11 will apply, answer me.
Section 11 will apply.
What are you talking about?
No, not I.
No, it was had the defendant appear on that day when the suit is dismissed for default, that he has a good ground to argue.
We have appeared.
No, on that day, again I am saying, you might have appeared in the suit on the day when it was dismissed for default. Whether you were there, no. Defendant did not file hajiras. No recording on the last order whether the defendant files hajira. I have checked. I knew it that Mr. Ghosh will take this plea, so I prepared myself in a.
Very well, my lord.
You will not find. If it is, then it is a dismissal under Order 9, Rule 3, non-compliance, Order 9, Rule 3, dismissal under Order 9, Rule 4, which says that the dismissal of the suit for default under Rule 3,
for non-compliance of the court
please,
order.
please, did not
My lord, even
prevent the plaintiff to file a fresh suit. Only thing is, provided it is within the period of limitation.
Order 23, Rule 1, your lordship is speaking of. My lord, I tell, my lord, one thing, my lord, I tell you, lordship, my lord, kindly see, we appeared in the show cause notice was issued, but
Under reason the court can dismiss if it is the non-compliance. Tell me. Show us that which is the provision in the court which says the dismissal of the suit for non-compliance.
my lord, my instruction is, we filed Hajira on that date.
We will go by the record which is sacrosanct, sir.
And one thing,
Order 9, Rule 3, when the defendant did not appear, and Order 9, Rule 4,
now, my lord,
no difficulty in bringing the fresh suit. Because there was no, there is no decision. That is what I said. Now, petitioner did not appear. Did not appear. Suit is dismissed. 8 and 9. Petition is different. The defense.
now, my lord, case to your document, there are three claimants of the property. Now, one Konika also files a suit. If you lordship kindly comes to page 208 once, my lord, kindly.
Sir. Yes, it says, sir. Because the defense, where it is not.
When the learned charges have refused the identity on the ground, there is two claimants in the suit property. The opponent and Pal files a suit, and one Konika first files a suit saying Minasha is.
Why you are espousing the cause of them?
No,
You claim your right. You claim your right.
No, because we have got a.
And they have also admitted. You are not denying that you have not made construction therein.
No, we are possession after purchase.
True, you are purchased.
Therefore,
You are in possession of the property. No doubt. You have protected your property by construction of the boundary wall. No doubt. Their allegation was. Now the question is, when we find that there is some debatable things that comes, it is better to protect the property so that it is not again encumbered to a third party.
I tell you,
That's the only way. That's the only way. We can't discard 1959 deed at this stage saying that it is a forced one. Sorry.
What you have to lot.
I'm sorry.
Can you see what the document?
Which one?
The mutation, the mutation certificate that is issued, that is also not a forced document.
Which one, sir? The difficulty is nobody is saying that it is a forced document. Nobody is saying.
But
this is a document which is there. Now, question is that what is the law? Which document would prevail? Obviously, you know law better than me also. That is a previous document or a previous deed of title that would prevail.
But I tell you, Lord, not but because he's asking for an injunction on the basis of a document title Xerox copy. Well, the original is not produced.
Let them, they have to prove it. Original certified copy if they come with that.
Not the original certified copy. Kindly see the seal. Kindly see the seal. The seal is different. At that point of time, 1959, this type still did not appear.
What did not appear means?
This was not the seal there.
Show us. That is what we wanted. I wanted this. Tell us. If the registration office says that this seal is a spurious one,
yes,
matter ends then and there.
I go one step ahead.
No. Let us see. Sorry. Let us see. This is the serious one. Show us that the
put a furious document, he should be punished. Not only refusal injunction.
we will not spare anybody. Don't worry. Don't worry.
Not only injunction will be vacated, but those will be punished.
Show us.
Opposition, page 200.
Show us the document.
Document,
Opposition?
218. 218.
18. 218.
Yes,
But seal,
Yes.
see, the seals are always made in the back portion of the document, my lord. This is
which? Sir, this is, I am really sorry. The person is not here in this world.
type of seals were not prevalent at that point of time.
Sir, I am asking you, sir, this is the original document which is there. It is the original document which was there. It will contain a seal. Now it is registered in the volume. The moment it is registered in the volume will be there, and anybody applied the certified copy, maybe after 5 years, 6 years, 10 years, then the seal which is prevalent on that particular day will be also put there on the certified copy. So you are trying to say these are the seals, and I also do not know where there are two seals which are maintained, one to be put on the original document and one in the copy. Please contain in the copy.
He do this, my lord, they,
But both the seals,
registration what he knows.
both the seals should be similar, my lord. You know,
Which one? No, this cannot come in the copy.
in the original, my
It will
lord.
not come in the copy.
Seal-
He is talking about this seal.
No, no, my lord, in the original, the seal should be in the back side. And when you take up a certified copy,
No, no,
That is-
no, 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 not always. Look at your deed. Look at this deed.
my lord, therefore, my lord, I was humbly praying, my lord, we have a strong
Wrong.
exception to the deed because the original deed they are not producing. They didn't produce the original deed.
Where? I am live. Otherwise, I would have said many things. I would have said many things.
This is a secondary evidence produced before the court. Well, they will not. After,
He will bring.
Stage we are.
what stage means? At this stage, Xerox copy will be produced before the court. That court will pass an order of injunction. Regarding last submission, my lord,
Where is the seal in the certified copy, and where is the seal? What you're talking about? Where is that seal?
my lord,
Where is your deed which you relied upon before us
Page,
in your petition?
page 80, 80.
It's we are keeping both sides. ये देखिए, this is called a volume copy. ये जो this- This is,
It is the first page and back sheet separately xeroxed. Separately xerox.
ये देखिए seal है, ये देखिए seal, ये देखिए seal. क्या फर्क होता है?
Well, 81 is the back sheet of page 80.
Certified copy का ये उन्होंने दिया है. Certified copy was supplied in 2010.
Different seals, my lord. Each seal of that seal, my lord, counted.
Something 80. This is what I'm saying.
Well, I've been instructed to submit, but these are the seal in the volume. These seals. I have not conversation with registry, my lord. But I've been told these are the seal in the volume. My lord,
I had.
I know that. That's why Balu will be known better than me.
In the initial days, many. Within 4 or 5 years of initial days of practice.
One thing more, my lord, last.
Sir, Mr. Mr. Ghosh, you can't argue in a first thing. You have said that the original deed is not forthcoming. Not necessary always that the original deed should come. He has produced the certified copy of the deed which he obtained from a concerned office. Now the question is, if this certified copy itself is a forged one, is a question of evidence that should come. The registry office will be called. They will have to prove it. Registration, certified copy, they will prove whether they have provided a certified copy. This is a true reflection from a book. These are the stage will come. At this stage, we have to proceed that this is the document which is forthcoming. And there is no improbability that this document would not have come. There is one thing. If it is improbable that nobody can think of, like a seal, you say that this seal and the seal which was prevalent, if you can produce a document before the court of that relevant period of time, showing that this is what the seal is used in a volume copy, then I can understand that you have shown that this is prima facie. But at this stage, we can't. And if there is a dispute as to the title, our contention is that the title has to be protected till the disposal of the suit. You cannot encumber, you cannot transfer this property to a third party who will come into again come into play. We can't. Question is, if it is a 59 deed in respect of the self-same property by a Khushibala, and then your predecessor have purchased from Khushibala in 1968, then the question would be which deed will prevail.
One thing more, madam, 1 minute, my lord.
Then obviously the law is certain. You cannot dispute that the 59 deed holder will prevail.
One more minute, madam.
We have enough thoughts. Only. Is it a question of title?
No.
Is it a document of title? No.
Then,
That's all.
can be considered, my lord, your logical
Straight.
report that we are in possession of the property.
Position is with you, admitted. We are saying so.
Therefore, my lord, they should not interfere with my position.
No, definitely not. Who says that they will interfere? We are recording that the position is with you. Because they admitted in the plaint that you are making a construction. That means you are in position. What more?
Only one statement.
Why they should be restrained? You can't prove it. 59 deed can't discard.
One sentence, my lord. He has relied on the plaint of so-called Khushibala. In my affidavit reply, categorically state my mother never filed any proceeding.
That is
No. When he's arguing, that's why.
We are not going into it. We are not going into
Then no problem.
It has been reflected in judgment.
whatever. We don't want to go into all these aspects. The appeal is at the instance of the plaintiff. We are not entering into those aspects.
Judges, therefore, when they dispute that title between.
Please, we are referring it.
How could he claim that he is the owner of the property?
Sorry.
Kindly seize the order.
1959 deed. That's all. At the instance of the plaintiff, assailing the order by which an ex parte ad interim order of injunction is refused by the trial. Next one. There appears a serious dispute on the title claimed by the rival parties. Several transactions have been made in respect of the properties, spanning over more than 60, spanning over nearly more than 60 years. And the litigation ensued when the defendant number 4 and 5, who are arraigned as respondent number 4 and 5, yeah, also 4 and 5, constructed a boundary wall in order to protect the possession and or interference from any squatters. The suit came to be filed by the plaintiff claiming to be the heirs of one Meena Saha, who according to the plaintiff was the original owner, having acquired right, title and interest in respect of the said property by a dint of purchase in the year 1959 from one Khushibala Dasi. Khushibala Dasi. According to the plaint case, as per the plaint case, their predecessor all along held and possessed the title in respect of the suit premises. And recently, the respondent number 4 and 5 started making boundary wall over the same, claiming an independent title. From a person who never had the right, title and interest therein. Since the appeal was against the refusal to pass an ex parte ad interim order of injunction, we directed the service to have been affected upon the respondents and also invited the respondent to disclose their stand by way of an affidavit. As serious question of forgery and the fraud having committed was raised by the contesting respondents. It revealed from the documents and the pleadings, reverse kore diyo, pleadings and the documents, annexed to the affidavit in opposition, that though they claim the title from their vendor, but the antecedents of the title manifest that the claim of title flows from the said Khushibala Dasi. Therefore, a common thread can be established in relation to a rival claims on the title, which is a matter of trial. The certified copy of the deed of sale executed by Khushibala in favor of Meena Saha in the year 1959 was annexed, was produced before the trial court, and is also annexed with the stay application filed in connection with the incident. The London judge could not comprehend the nuances of the incident of title flowing from the deed, and surreptitiously jumped to the conclusion that it is not a fit case to pass an ex parte ad interim order of injunction. Even at this stage of the ad interim order of injunction to be granted in favor of the plaintiff, there is no fetter on the part of the court to examine the claim of the contesting respondent. And we find that the question of forgery and the fraud, though taken by the contesting respondent, but have to be proved by a cogent evidence, as the certified copy issued by a competent authority, which is relied upon by the plaintiff appellant, cannot be discarded at this stage. Even an information even an information sought from the additional district sub-registrar records, as relied upon by the contesting respondent, does not indicate that the purported deed of 1951-9 is a product of a fraud and a forgery without any further corroboration and or reliable piece of an evidence. What it indicates that no information regarding the aforesaid deed of 1959 can be provided, as the volume in which it is so recorded is untraceable. If the government record is not traceable and the certified copy appears to have been given in 2010, appears to have been given, it does not affect the title nor render the deed automatically ineffective and or void. Furthermore, the certified copy of the registration of the deed was obtained in the year 2010, which is apparent from, where is that page?
80.
Which is apparent from Annexure D, and the information sought to be relied upon, having obtained from the additional district sub-registrar records, revealed that the said record becomes untraceable, and the general diary was registered with the general diary was lost with the concerned police station on 21/9/2011. That is much after the issuance of the certified copy, as relied upon. Such being the position, we cannot arrive at a conclusive opinion whether the deed of 1959 is the outcome of a fraud or the forgery, as it is a serious tribal issue. Stop. The moment the court finds that the tribal issue has been, the case relating to tribal issue, now the moment the court finds that the issues are tribal in nature, it is an ardent duty of the court to protect the interest of the parties. Stop. The plaintiff reveal that the position is with the respondent number 4 and 5. And an allegation is made that the said respondents have constructed a boundary wall, which ipso facto proves the assertion of their title and the position in respect of the suit premises. Stop. Since there is a serious dispute as to the title, as we find that the contesting respondents claim title through a Khushibala in favor of their predecessor in the year 1968. I have started the sentence. And the claim of the plaintiff originates from the purported deed allegedly executed in the year 1959, we thus find that a prima facie case that we find that the plaintiff is entitled to protect the property from further from any further dealings, as it would cause a multiplicity of the proceedings and proceeding. Full stop. In such view of the matter, we set aside the impugned order. Full stop. The respondent number 4 and 5 are restrained from encumbering. No. You have asserted they are claiming encumbering, transferring, alienating, and or dealing with and or creating a third party interest in respect of the suit premises for a period of 2 months from date or until further order, as may be passed on an application for temporary injunction. Stop. Since the contesting respondents have entered appearance, they are permitted to file affidavit in opposition to application for temporary injunction. 4 and 5. Within 10 days from date. A reply, if any, shall be filed within 5 days therefrom. So the courts shall proceed to hear out an application for temporary injunction after ensuring that the copy of the application for temporary injunction is served upon all the defendants, and shall ensure that the application for temporary injunction is disposed of within 2 months from the date of from date. Stop. In the event and because of the unavoidable and unforeseen circumstances, the trial court is unable to dispose of an application for temporary injunction, it is open to the learned judge to consider the prayer for extension, if made, and shall be free to pass any order as he may deem fit and proper.
So far as 1, 2, and 3 are concerned, we also prayed for injunction against them. They entered appearance. We have served them.
They are appearing. They are not appearing here.
I have served them.
Anyhow,
Probably one day they have appeared. Records reveal so.
I do not know. Anyhow,
The record will show.
I do not know. If they have appeared, let them.
So the injunction should be also in. They know also.
No. Construction, they are holding the whole position. They should. They should.
They have appeared, Lordship.
Pursuant to your lordship's direction, I have served. Lordship, the track report says that it is still on hold from Lordship 26th of February. Even
Is this-
today,
It is still on?
on hold. Lordship, kindly see.
Let us see the next week, otherwise
Lordship, since Lordship 26th of February.
write a letter to the Postmaster General to have a certificate in this regard that why it is on hold. Item is on hold. Why?
Lordship, my interim order will expire on 20th.
Next week it is. Tomorrow. Yes. It appears from the affidavit service filed today that the service has not been affected, as the postal article is put on hold by the postal department. The advocate and record of the appellant is directed to take an appropriate steps in this regard. To stop. The interim order which is granted earlier is extended for the further period of 3 weeks from date or until further order, whichever is earlier.
Lordship, the matter will appear next week
After 2 weeks.
under the same heading, Lordship. Under the same heading.
You want a different heading? তো যখন ধরছি তখন ধরেই নি।
Paper books are not ready, Lordship. I have a comprehensive list for your Lordships to see the steps that have been taken by us as well as by the department, Lordship. My Lord, as on 13th of February, we had sought for inspection, but my Lord, we were 30th of March. We were told that the records are already before your Lordships, therefore it could not be brought down to the department for us to carry out the inspection.
Let the record be sent down to the department immediately, so that the inspection as sought for can be carried out. List the matter,
My Lord, we'll need 4
Next week.
weeks. My Lord,
prepare overnight.
My Lord, at least 3
Prepare
weeks,
overnight.
Lordship.
Prepare overnight, yes.
My Lord, there is one another.
Thursday week.
My Lord, the records are quite big, my Lord. It may not be possible next
Maybe
Thursday.
in the first week of
Do it,
April,
do
my
it,
lord,
do it in this week. Get it done during this vacation.
But
Come on,
kindly
20
keeps it in April at least,
28.
Lordship.
My lord,
28
28, I will
come.
not be available. Kindly keep it in the next one, but
28.
My Lord, 28th, even I have a personal difficulty, Lordship. My mother is undergoing an operation on 28th. Kindly keeps it in first week of April, Lordship.
First week of April.
I'm most.
My Lord, there is one other pressing issue, Lordship, that if Lordship will kindly consider that the daughter has sought for our help in a pretty desperate state and she has addressed a letter that could be given to your Lordships, Lord. My Lord, it is not for his viewing. It is, she has
Application be filed, I don't
specifically
know.
requested if that can be given to your
We
Lordships.
can't do it in this
What
way.
this is, my lord. Appeal will be decided on the basis of the materials on record.
My Lord,
before the
she's in a very desperate state, my Lord. She has sought out help from us, but my Lord, we are not in a position and therefore we have
There's a
brought it
letter.
before your Lordship.
File an
Lord,
application.
I
don't know what
cannot
is the
file an
application. If the
application
daughter has
because,
in fact filed the application.
Custody.
excuse me, kindly.
My lord, I will have to object to my lord documents. being
My Lord,
handed
this
up.
is
Yes.
May it please your lordship. Now, this appeal is directed against the order dated 30th June 2023, whereby of the London Court of Appeal below, whereby
Order 22, Rule 10 disposed of.
yes, allowed,
Allowed.
and
Now tell us that who died and then why Order 22, Rule 10? Or if there is any devolution of interest, how?
yes. Well, I tell you,
Read with section 211 of the Indian Succession
sir,
Act.
I tell your lordship,
Read
the
with section 211 of Indian Succession
Let
Act.
us see. The will is there. Probate has not been granted.
no.
Let us see.
Even I think that application for probate has not yet been done.
Then
Made.
who are they?
Yes, I tell your lordship the
are
background of
they?
this case in a nutshell. My lord, originally one Annapurna Dhali, she was the plaintiff. She filed a title suit for declaration and permanent injunction. So during the pendency of the suit, she died. So after his death, after her death, her heirs and legal representatives, being her sons and daughters, all were substituted in her place and state. And since then, they have been they contested the suit. Now, my lord, ultimately, the suit was dismissed on the ground that they could not substantiate their stand of that they were the absolute owner in respect of the suit property and possession. So the learned trial court dismissed the suit, and against that judgment and decree, my lord, they filed an appeal, and they also all the heirs of that original plaintiff, they contested the appeal. But during the during the continuance of that appeal, only the respondent number 7, the opposite party number 7 hearing, he came up with an application under Order 22, Rule 10, that by virtue of an alleged will executed by her mother, he was appointed as the executor of the will, and thereafter he played for the special status to contest the appeal in the capacity of an
He is already a party to
already on record.
Only
Now the
thing is
court,
that
now the
wanted to contest not as a
appellant,
not in his individual capacity, but in an official capacity of an executor.
executor, but other respondents, other respondents upon whom that alleged has devolved, but they did not participate anyway. No, your lordship, I shall show to your lordship that the court disbelieved the very execution of that will. I shall place that portion also, and also the court disbelieved, but rather he expressed their strong doubts with regard to the plea taken by the respondent number 7. In spite thereof, allowed that application under Order 22. Even after that, I am showing to your lordship.
Can this finding of the court is valid in an application under Order 22, Rule 10? Can he may say anything about the genuinity, the authenticity
No.
of the will?
Yes, that's right. Your lordship is
Can
perfectly
he
right.
so, sir?
No question genuinity, but
It's not a
it was
probate
so
court.
prima facie. The
Whatever, sir.
so he has recorded those things.
How?
Recorded those things,
How?
and
These
no,
are
lordship,
all obiter, I would say, unnecessarily. It was not required to be gone in.
very good, Lord. So
Nothing
when
has come out,
lordship
not a
can receive,
probate court, and he will say the genuinity.
no, lordship can receive when he is coming with that application, Order 22, Rule 10. According to the respondent number 7, the alleged devolution occurred during the pendency of the suit, and the document was with him. But in spite thereof, he did not place that document before the court, in spite of having that document in his possession, on the plea that I was ignorant about law, the importance of placing this document before the court. I am showing to your lordship. So, Lordship will kindly page 54, the Lordships will kindly come to page 54. 54. Yes, that's the application of the response number 7, page 54. The second paragraph. So, in order to allow the order 22 rule 10, the court must be
The court
satisfied
has-
with the
the court
facts
has-
of the.
Sir, the court has taken note of the judgment of the Supreme Court, AIR 2006 Supreme Court. I think the first of the judgment, you can trace it from our High Court by none less than Justice Anil Kumar Singh.
That I have seen.
84
While,
84 CWM.
yes, 81, 19, AIR 1981.
No,
I have
no,
that
84
judgment with me.
CWM.
Lord, that is on a subject to your lordship's correction, or I may be wrong, Lord. So at the time of
Sorry, the very, very apt one. There is a will. The will has not been declared nor probated as yet. There is no fetter on the part of the court in bringing the executor together in the proceedings. The court has taken a very, I would say, very apt decision that in the event any judgment is passed, the effect of the judgment would remain in suspension until he proves that the will is there. He proves the will.
yes, Lord,
That's the very innovative
but
way.
Lord, I am asking this question to myself. When the court itself is not satisfied, I'm sorry.
होता है कि 213 में एम्बार्गो है that executor with the probating cannot no decree is that it will be in the just suspension in the suspension. এই ইন্ডিয়ান সাকসেশন একটা কোথায় আছে পেয়েছি ছেড়ে দাও no right as an executor can be established in any court of justice unless a court of competent jurisdiction has granted a legal state court has granted decision. It says that इसका right नहीं है लेकिन 211 is regarded as a legal representative for all purposes of the state. So, definitely, unless the probate is granted and then carry out, he becomes a legal representative for the local government. And there are restrictions in the act itself about the executor what he can do. He cannot sell the property without the permission of the court. And all these things are there.
Yes, Lord. So Lordship kindly says that under Order 22 Rule 10, if the court is not self-satisfied with the facts for which Order 22 Rule 10 is being filed, so it's a discretionary. It's not that
not a discretion, it's
No.
a devolution. First thing is a devolution of interest.
interest.
And the devolution of interest occurred because of the execution of the will.
Right.
Now, an executor is regarded as a legal representative
Yes,
under
under
section
211,
211 of the Act. If he is regarded as a legal representative, then he is entitled to represent the estate of the deceased who has left the will.
Yes.
But 213 creates an embargo that he cannot, no right would come into it unless the court of probate grants
Yes.
or make a seal off
Yes.
of the will. Secondly, there is no difficulty in filing a suit for title or of any kind, despite the fact that the will has been probated or not probated.
The
The law as it stands is, the Supreme Court has also said that you bring the executor as a party if some third parties are claiming an interest, so that being a legal representative, he can protect the interest of the state. He cannot claim title, but he can protect. If any judgment is passed against him, that would remain binding. This is what it says. But if any declaration or any judgment or a decree is passed, that will not be given effect to unless he obtained the probate.
probate, that's right. Now, Lord, that is the law is settled, but that's the settled principle of law. But the
So
question
you want
is,
to unsettle it.
pardon?
You want to unsettle it. You say it's a settled principle of law.
Oh, no, no, no.
Now
I
you
do not
sought
want
to
to answer.
unsettle
No,
it.
no, no, not at all. But Lordship kindly do me, sir. What I want to submit, Lord, or subject to Lordship's correction, when he is approaching the court, that's very important.
Immaterial.
No, my Lord,
There is
so
no
far as-
period of limitation. There
I
is no
subject to
period
Lordship,
of limitation provided under Order 22 Rule
may I
10.
rely upon Supreme Court
Sorry.
judgment? I not subject to your Lordship's
Yes,
correction.
no period of limitation is
No,
required.
may I-
For what?
yes, may I read it?
Yes.
So, this has been reported in 2000 AIR 2002 Supreme Court 2180.
What it says?
Yes. May I read it from the first of from the head note? Thereafter, I shall go to the.
Don't read the head note.
Okay,
Give a copy. Head
Yes,
note is always
paragraph
very,
5. Yes.
very deceptive.
Paragraph 5. May I read it? Paragraph 5. It has.
Just 1 minute. I have a very bad habit of reading the judgment in a different manner.
Okay. Yes. Yes. The last portion of that.
But that's the correct approach. How it affects this case?
Lordship can says he has he came up with the application, or rather he disclosed that the existence of that alleged will long after during the pendency of the appeal. Now, Lord, although Lord, Lordship can say here the party, I mean the transferee and the party is the same person. In this case, what happened, Lordship can says, but if no such step is taken, the suit may be continued with the original party.
This is how, because it's a devolution of interest, sir. In a partition suit, suppose a person, a co-sharer, has divested his right title and interest in favor of a third party, and the third party, the transferee pendentility or
Yes.
transferee did not come forward.
Yes.
Yet the suit will not abate. It will continue,
with
and
the,
if any decree is passed, it shall be binding on a transferee. Similarly, in this kind of a thing also, Order 22 Rule 10, the devolution says that the right of the original, because he is protecting the interest of his purchaser. So, if the purchaser has a knowledge that his vendor is a party to a particular proceedings, and even if he has not taken steps, he would be bound by whatever the judgment that would come there. That does not mean that his right to approach get lost.
But
What are you talking about?
the party and the transfer is the same person.
Maybe.
He has sufficient knowledge that he was a party to the suit, the
Sir,
party to the appeal.
Sir, the gentleman has left. Otherwise, you would have.
No, but Lordship,
Really, otherwise you would have.
no, Lordship, the court disbelieved that the plea.
Not required. He cannot say that the will is genuine or ingenuine.
No, not that.
Sorry, he
not
can't
that.
say.
Not that. But even after that, Lordship kindly says from the order itself, it is annexed to the to my appeal. Lordship kindly says at inner page. Yes, inner page 9, my lord. Inner page 9. From the may I submit, my lord?
Yes.
Lordship can see inner page 9. Page 9 of the judge. But Lordship will kindly take trouble to come to page 9 of the impugned order. Impugned. Annexed to my memo of appeal.
Okay. Is that just so?
Lordships have got, yes.
Nevertheless, read
It is true that the will on the face of it, no, I'm not showing that. Face of it suffers from various inherent anomalies. There are corrections, overwritings, and discrepancies in dates, etc., which gives rise to certain doubts. the very fact that that is one aspect with regard to the effects in its execution, and second thing, the very fact that it has surfaced so many years after its purported execution and death of the testator also casts a cloud on the propriety of the document, more so as the petitions preferred by the appellant do not clearly reveal the source from which, how, and in what manner he came to learn about the will. So he disbelieved the plea taken by the respondent number 7 with regard to, because Lordship Kali says what from page 54, Lordship Kali, just I am trying to impress upon your Lordship in my humble way, page 54. What is why he has come with this application? What is the plea he has taken? Paragraph 2. May I read it, Lord? At page 54. That during the pendency of this appeal,
Yes.
Your petitioner in the month of February 2022, for the first time disclosed, Lordship can say, not discovered, disclosed, that about the last will and testament dated such and such, as executed by his mother, so and so, since deceased, the original plaintiff or the title suited. Actually, now the plea he has taken, page 54. Page 54. Yes, actually, your petitioner, being a layman in the legal arena, had no knowledge about the importance of disclosure of the said instrument. By virtue of the said will, he has been. Therefore, although it was in his possession, although he was contesting the appeal, Lord, he deliberately did not bring it. So court has also dismissed
I am
this.
asking you, sir, these are all the grounds relating to attraction of the provisions of Limitation Act. Firstly,
No,
there is no limitation.
True.
There is no period of limitation provided under Order 22, Rule 10. There is no period of limitation provided for filing a will for probate.
Yes, that's
how it is, whether it is knowledge or no knowledge, immaterial.
no, the thing is that court itself is not satisfied with the.
Then what for the appellate court are set up? Then what for the appellate courts are set up? Because they will correct the finding of the trial court. If the trial court has exceeded its jurisdiction, then it is a duty of the appellate court to bring the trial court within the purview of the boundaries, not to travel beyond the boundaries.
But the thing is that the judgment, I try to relate this.
The very simple thing is, sir, he is already made a party there. He discovered the will wherein he has been appointed as an executor. The will has not been probated. 2006 Supreme Court judgment is very categorical, which says that if the executor has come, you should implead them as a party. There is no difficulty because any judgment which would be delivered in that case in presence of the executor, at least he is aware of it. But the effect of the judgment should remain in suspension until the probate is granted to the will. So no difficulty.
May I submit it here? Lordship will, in that judgment, what it has been stated, has been held, that in order to bring the party who has not been made a party to the proceeding. Yeah. So, but here the respondent number 7 is already a party.
The difficulty, that is what I'm saying.
So I'm asking.
A person may have more than one capacity.
So I'm not on that, Lord.
Again, I'm saying because of one reason.
No, I'm not.
How can you make a party? A person by name is made a party in one capacity. The person is required to be made a party in a different capacity. Let us see, for example, there is a suit for declaration that this property is a secular one and this property is not vested to a debitor. The person who is asserting his right is individually, by name, he has been made a party. Now, the question then arose whether this deed of endowment which was done, creating a debitor, whether that deed of endowment is legal or valid. the amendment was made, challenging that particular deed of endowment also in the suit. And it appears that the defendant number 1 is a Shibayat and a trustee by virtue of that endowment in respect of a debtor's property. What do you think? He has to be again made a party by way of an addition, because the judgment is to be passed in presence of a Shibayat and a trustee whose primary duty is to protect the interest of the DT.
Right.
Can he not? Then
No.
a same person by name arraigned as the defendant as number 1 and defendant at a defendant number 9. No. It is the defendant number 1 who will be described in 2 capacities. One individual,
Individual and
another
special capacity.
This is what he really wanted that I should also be described as an executor to the will,
But
apart from my legal right.
Lord, this prayer, Lord, I'm asking this question to myself, subject to your lordship's correction.
Now,
Whether can that be done by
now without knowing and understanding, if you
No, I have understood, Lord. Lord, it is the only thing I'm submitting to
I
your
have
lordship.
given you enough time and enough energy on this.
Lord,
The way you are really trying to unsettle what is
no,
absolutely
I'm not
settled
trying
in
to
this.
unsettle the thing. Lord,
There
the
is no
only
ambiguity, there is
submission, Lord,
no
lordship,
confusion in our mind on a proposition of law prevalent today. Even the Supreme Court is conscious of that. You are trying to upset
No,
everything.
I'm not. Lord, only one submission, lordship, I want to make. Lord, Order 22, Rule 10 is applicable when, in order to make a person a party. But when, no, I'm just subject to your lordship's correction. If one is already a party,
Then please look at the provision
yes,
of Order 22.
Order
Rule 10.
22, yes, I'm grateful to your lordship. Lord, I may be wrong, Lord, that's true. Lord, what is,
That's why I say I have to unlearn what I have learned from,
no, no, kindly,
and I'm ready. If I am
Yes.
wrong, I am wrong.
no, that's,
I will correct myself. Look at
yes, procedure in case of assignment before final order in suit. Order 22, Rule 10, yes. In other cases of the assignment, creation, or may I read it, madam? Assign, creation, or devolution of any interest during the pendency of a suit. This suit may, by leave of the court, be continued by or against the person who or upon whom such interest has come or devolved. Very good. The attachment of a degree, the attachment of a degree pending an appeal therefrom shall be deemed to be an interest entitling the person who procured such attachment to a benefit of subsection 1. It is for the purpose of bringing a person.
this is what you're understanding reading.
But
our reading is different. It simply says that in other case of an assignment which is not provided anywhere else, any other case of an assignment, creation or devolution of any interest, does not specify which interest, any interest. What creation of an interest or devolution of an interest during the pendency of the suit, then the suit may, then a leave of the court is required. By leave of the court, be continued by or against the person to or upon whom such interest has come or devolved, has devolved. What it says is, it does not say addition for the first time. No. It says if the devolution has taken place, then against a person, the person is defined. Continued against a person means what? Then there is already a person, but may be continued against a person. To be continued by or against the person. To be continued by or against the person. Means the person means whom? To whom or upon whom the devolution or creation has been done. So it does not say that non-party to the proceeding can only be done under Order 22, Rule 10. If that is the understanding, then I am really sorry that I do not think that it says so.
Lord, may I rely upon
Says
another
so.
judgment? It's my
Sorry,
Lordship, 1958, AIR 1958. It's a very. It says, Lord, although it has considered section 146. Yes, oh, I see. Sorry, I thought, Lord, may I hand up? Should we kindly consider this? But head note A, my lord, even if a suit is pending when the transfer in favor of the appellant was made, that would not affect the result when no application had been made by her to be brought on record in the original court during the pendency of the suit. The application made to the appellate court cannot be sustained under Order 22 Rule 10 when the transfer in favor of the appellant was made prior to filing of that appeal and not during its pendency. Not,
I think enough. This is the time that we should now assert that it's enough.
Your Lordship.
Enough. Nothing. I'm telling you. The instant appeal arises from an order number 41 dated 30th June 2023, passed by the Additional District Judge, Fast Track Court, First Court, Fast Track First Court, Aleppo, in title appeal number 62 of 2019, by which an application under Order 22 Rule 10 of the Code of Procedure filed by the respondent is allowed. At the very outset, we must record that the appellate court should not give any indulgence to an unmeritorious proceedings and should try to nip the proceeding in bud at the stage of its admission under Order 41 Rule 11 of the Code of Procedure. Simply because a statutory right is conferred to file an appeal against the impugned order should not give any premium that the appellate court should hear the matter when the point so agitated before the appellate court is somewhat settled by the catena of decisions rendered in this regard. More particularly, the court should not encourage the litigations at the circumference of a procedural aspect. More particularly, as we found in this case, when an application for devolution of interest under Order 22 Rule 10 of the Code is filed, we invited the counsel for the appellant as we find that the order impugned in the instant appeal, the ultimate order, the ultimate decision impugned in the instant appeal does not require any interference. According to the learned advocate for the appellant, the provisions contained under Order 22, Rule 10 of the Code of Procedure is intended to add a new party to the proceedings and cannot apply in case the party already impleted therein. The reliance appears to have been made on the judgment of the apex court in case of Jaskirat Datwani versus Vidyavati and others, reported in AIR 2002 Supreme Court, page 2180. Wherein it is held, quote paragraph 5. From the meaningful reading of the findings as quoted herein above, we do not find any quarrel to the proposition of law laid down in this regard. More particularly, the broader aspect of the provisions contained in Order 22, Rule 10 of the Code of Procedure. It has been held by the apex court that mere devolution of interest during the pendency of the case does not put an end to the said case, simply because that one of the party has divested his right title and interests therefrom. It is further held that even if a person is not brought, the person upon whom a right is created or devolved is not brought as a party, yet he would be bound by the decision taken therein. In presence of his vendor or the predecessor, as the case may be, and cannot take an independent right, nor can take a plea that being not a party to the proceedings, he is not bound by the ultimate judgment or the decree passed in a proceeding. The language employed in Order 22, Rule 10 of the Court does not suggest that that it can only be activated when a devolution is created into a third party, and such third party is to be added as a party therein. Rather, the legislative intent is manifest that in case of creation or devolution of interest, the proceeding can be continued by or against the person to whom or upon to or upon whom such interest has come or devolved. the person cannot be given a restrictive meaning as tried to be projected by the counsel for the appellant, but has to be construed in a broader perspective, keeping in mind the purpose of incorporating such provisions in the procedural law. A person can be arraigned as a party in a proceeding in multiple capacity so as to bind him in all such capacity. And therefore, it is inconceivable that a person already implemented as a party in the individual capacity cannot represent himself in an official capacity if the devolution of an interest or the right is created in the interregnum. Even in case, even in a case delivered in Saila Bala Dasi versus Nirmala Sundari Dasi and another, reported in 1958 Supreme Court, page 394. The apex court has not laid down any law that a person cannot be described in a dual or other capacity if the occasion so arises by virtue of a devolution. What has been held therein that the transferee pendentillate, that the transferee of the property that the transferee pendentillate shall not seek his addition for the first time before the appellate court if he has not taken any steps under Order 22, Rule 10 of the court when the suit was pending before the court, before the original court. The court was conscious that bringing a person for the first time in the appellate court may create an embarrassment to the successful litigant, being conscious of the fact that even if he being not a party in the original proceeding, but claiming a title through a party to the original proceeding, have a right to file an appeal by virtue of the provisions contained under section 146 of the Code of Civil Procedure. And therefore his interest cannot be said to have been shrouded and or effaced in the following, quote paragraph 7 therefrom. None of the judgments cited before us is pointed to an issue that a person already made party in his individual capacity cannot apply under Order 22, Rule 10 of the Code of Procedure as he has acquired and other capacity by virtue of a creation or devolution of an interest in respect of the property. Since we are not convinced with the proposition of law as argued before us, in order to bring clarity, the salient facts are required to be adumbrated. The suit was filed against several defendants, including the defendant number 7, for various reliefs. During the pendency of the suit, the defendant number 7 applied under Order 22, Rule 10 of the court, claiming a right as an executor by virtue of a will executed by the predecessor of the parties. What the defendant number 7 intended that he should be described not only in his individual capacity, but as a capacity of an executor. And therefore, the court should allow the said application. The trial court, in our view, though arrived at the correct ultimate decision, but made certain observations which were unwarranted and beyond the jurisdiction or the powers conferred upon it. The trial court proceeded to make certain comments on the genuinity and or authenticity of the will, the purported will, being not the court of probate, and therefore such findings was unnecessary and should not have been reflected therein. We thus observe that such findings shall not have any persuasive effect in any proceedings, any effect in any other proceedings. Postal. So far as the plea of approaching the court belatedly is concerned, we do not find any provisions in the Limitation Act where the period is reserved for making an application under Order 22, Rule 10 of the Code of Procedure. Nor we find any period of limitation for applying, for making an application for probate. If the occasion to apply for probate does not accrue, simply because a person has approached the court belatedly, when admittedly no period of limitation is provided therefore, we do not find that such may act as a deterrent, more particularly in the original proceeding, to deny the reliefs claimed under Order 22, Rule 10 of the Code of Procedure. The belated application may not be entertained if the same is taken out for the first time before the appellate court in view of the judgment rendered by the apex court in Srimati Sailabala Dasi Supra, but the said situation has not arisen as yet. And therefore, the principles of law laid down therein has no manner of applicability in the instant case. The appeal is thus dismissed with cost assessed at 10,000 rupees.
No, no, my lord, lordship will kindly,
Why not?
no, lordship will kindly.
Why not?
No, my client will be, no, lordship will,
No. He's a very good, formidable litigant. Let him.
no, not a formidable. Lordship will kindly consider. No, lordship will kindly do not impose.
What?
At least Uh, 11 Milord, I am for the plaintiff. I am for the defendant.
Dependent. Are you an appellant?
Milord. I am for the appellant. I am for the appellant, Milord. Mr. Anil
That
Kumar.
you have not read the brief, you do not know anything about it. What do you want? Tell us.
Mr. Anil Kumar Chattopadhyay was
Where is he? He was there yesterday.
he is now Narayani Hospital for eye surgery and praying for adjournment, Milord.
This is my appeal, Your Lordship. There's an application, Your Lordship.
Who are you? Not application. First is cross the hurdle of admission. Then the
Yes.
application.
Also, Your Lordship, there's an application for condonation of delay, 8 days, Your Lordship.
8 days. Have you served the copy?
Yes, affidavit of service, Your Lordship.
Hey now. Hey. শোনো কোর্ট এস্টাবলিশমেন্ট থেকে এখন আছে রেজিস্ট্রার not be located, madam.
Your Lordship, there was a caveat, Your Lordship. The advocate has been served, Your Lordship, personally.
Where is that service?
I have also served a mentioning notice to the advocate.
Received by Mr. S.K. Mondal.
Yes, yes, Your Lordship.
He filed a caveat for whom?
It was not written, however, it is for all the parties, as per the instructions. They're all family members.
September 14, 2023. September. Applied for certificate copy. 6 months. 16, 3 का कैलेंडर नहीं এই 2023 এর ক্যালেন্ডার আছে court order. 19th. इसका मतलब है 23. So last one. So 16th of 30 days. Sure. Madam, there is no limitation. Period of limitation is 90 days from the other court.
Yes, Your Lordship, it has crossed the period of 90 days. Your Lordship.
No. Madam, the order was 14th of September. What are you doing? 14th of September was the date of the order. You applied for certified copy on 26th of September. So 12 days gone. And then it was made ready for delivery on 19th of October. So from 19th of October,
Yes, yes.
another
Your Lordship.
18 days that expired within the period of limitation.
Yes, yes, Your
And
Lordship.
then you have filed it in December. So 90 days did not expire.
Yes, yes, Your Lordship. There must be a mistake then, Your Lordship.
Then
Kindly condone the mistake, Your Lordship.
there is no question. We will simply say that there is no period of limitation.
Yes.
Even our stamp reporter has not indicated there is any delay.
Yes, yes. Grateful, grateful, Your Lordship.
Now, argue on merit.
Yes, Your Lordship. So the respondents herein, they have preferred an application in the learned code below for grant of letters of administration. Now we have contested the letters of the application.
Letters of administration with the will annexed or not will
Yes.
annexed?
Annexed. Will annexed.
Will annexed.
Yes. Thereafter, we have contested the said application. During the pendency, Your Lordship, they have taken out another application under Order 39, Rule 1 and 2 for grant of injunction. Thereafter, the learned
What
code
injunction?
injunction with regards to status quo on the property which has been stated in the will itself.
Who are they?
They are basically the heirs, or legal heirs of the deceased, Your Lordship.
Correct. The letters of administration. Now it's an administrator appointed by the court.
No, Your Lordship. It's an application for letters of administration.
Pendente was not appointed.
No. There was no prayer for administrative pendente, like Your Lordship. Just for application for grant of letters of administration
By whom?
by the
Yes.
by the heirs.
And then what injunction? Who are you? What is your relation?
I am also an heir, Your Lordship. I am contesting the will, and thereafter they have prayed
You
for.
have lost the caveat and you filed an affidavit, contentious cause. It was
Yes,
relegated as a suit.
yes, Your Lordship. The issue herein is that, Your Lordship, the probate court cannot grant any injunction. That is my only prayer.
In all such situation, it cannot grant injunction.
I'll show it to Your Lordship that there was no such situation.
That is a different. You say that the probate court cannot grant injunction. That I ask.
Yes.
In all conceivable situation, it cannot.
Yes, Only in two cases it can, your lordship. Only if there's a prayer for administrator pendent light, only in that case the learned court below can grant.
It is the
No,
case.
your lordship, it is the prayer is only for grant of letters of administration. And it's a in this proceedings, the learned court below cannot grant.
I am asking you why. It's a letters of administration application with a will annexed.
Yes.
Now, once the administration is granted, then the letter of administration in whose favor it is granted, he is obliged under the law to take care of this and protect the interests.
Yes, your
And
lordship,
if
definitely.
he says that the state is being burdened with any kind of a liability, can he not seek an injunction?
I'll show it to your lordship through judgments, your lordship. I'll show it.
Show us the judgment first. Particularly our High Court judgment, our High Court view, and the view of the Supreme Court.
I have view of the Supreme Court, your lordship.
Yes, show us.
Your lordship would kindly come
Just
to
1 minute, don't worry.
your lordship would kindly comes to the impugned order, your lordship. If your lordship would kindly.
No, this judgment justify.
Yes, your
What
lordship.
you want to derive from this judgment.
Yes,
Let us
your lordship would comes to para 14.
please. We have
Yes,
where Krishna Kumar Billa's judgment has been quoted
yes.
with approval. What you want to say? Tell us. We have gone through it.
Your lordship,
Tell us. Tell us
Yes,
the
Your Lordship, yes.
proposition which you want to say that no injunction can be granted in a probate.
Yes, the judgment that has been cited there, Krishna Kumar Billa, that particular paragraph, Your Lordship, the
Yes,
last line of para 57, which has been referred.
yes.
A question of title arising under the Act cannot be gone into the probate proceedings. Construction of a will relating to the right, title, and interest of any person is beyond the domain of the probate court. Your Lordship,
Who disputes? Does it say that no injunction can be granted?
Your Lordship,
I'm asking this question. You have raised one question
yes, yes.
that in a probate proceeding, injunction cannot be granted. I say in all conceivable situations. You said absolutely. I am asking you a judgment. Tell us from where its Supreme Court has said.
Your Lordship, I'll cite another judgment. This judgment especially talks about the right title.
Madam, we are
Yes.
conscious.
Yes, yes.
We are conscious that what are the limitations of the probate court.
Yes, Your Lordship.
Concentrate on that point which you have.
Yes,
We have
yes.
not gone into the merit. Merit is the
yes.
latter part.
Also, Your Lordship, I would point out one.
Please
Yes.
show us that it cannot be granted. Show us.
Your Lordship, can I indicate one thing, Your Lordship, from the impugned order itself, Your Lordship?
No, we'll go into the impugned order. First, the proposition of law that the probate court is denuded of power to pass an injunction. That's a very simple point.
No, put a citation.
See? What? She has said so.
Yes, Your Lordship. Para 15, Your Lordship.
Yes.
Also, I'll come to para 14 as well. First,
Tell
para
me
15.
first.
Yes.
14 or 15?
Both, Your Lordship.
Yes.
But for para 14, I need to indicate one point from the impugned order itself.
Just let us read both.
Yes, yes.
Yes.
Yes, Your Lordship. Can I indicate one thing in the impugned order, Your Lordship?
Suppose if there is a two division bench judgments, one of our High Court, another of a distant High Court, which
You know-
will have the more binding effect.
Okay. Okay, Your Lordship. Then I'll bring one
No,
division bench judgment.
which will have a more binding effect.
Yes, Your Lordship. But can I indicate
I'm
one?
asking, please, the
Yes.
question, please understand. There is another division bench judgment of our High Court in Amal Kumar Atul Bala Dasi,
Yes.
AIR 1951, Calcutta,
Yes, I'm aware, Your Lordship.
which says no problem.
Your Lordship. Yes.
The another division bench has departed therefrom.
Your
It's a
Lordship.
different High
Atul
Court.
Bala Dasi.
I mean, what I am asking is that if the division bench judgment of our High Court has laid down a principle, and it appears the other High Court, a division bench, has taken a contrary principle, then what is the duty of the court or coordinate bench? To follow the judgment of our own High Court,
Yes,
or to
absolutely.
follow a judgment of a different other High Court?
Of your own High Court. Yes, Your Lordship.
So
I agree with Your Lordship.
I was conscious of this judgment because that's why I say our High Court.
Yes.
Cite a judgment of our High Court, and then you said Supreme Court. We said fair enough. Article 141 binds us.
Can I indicate one thing in Atul Bala
But our
Dasi?
High
Your
Court
Lordship?
has said something else.
In para 15, Atul Bala Dasi, the judgment has been referred.
In subsection 2, I observe that it is not necessary to consider the implication of the division bench of the High Court could be pending charge of the distributor. That's pointed out that there is no such clear need for and then
Where is the Atul Bala Dasi's judgment?
I have not brought a copy, Your Lordship. It's just the reference here in para 15. I'll bring a copy next day, Your Lordship. However, I'll indicate one thing in Atul Bala Dasi. It's under section 247 for application.
But that was 269. 2 was also taken into account.
Yes, Your Lordship.
So if the division bench of this court has taken note of the provisions and then held that there is no bar in passing a temporary injunction in such, then we'll have to take a dissenting view.
However, Your Lordship, in the Act itself under 269.
That is why I just
Yes,
wanted
yes,
to read
yes.
that judgment, that what
I'll bring-
interpretation has been assigned in the Atul Bala Dasi.
I'll bring a copy, Your Lordship, on the next day.
Otherwise, we will not be able to.
Gratefully.
I can trace the relevant paragraph from the soft copy. That is the difficulty.
What?
Of the Atul Bala Dasi's relevant.
What it says?
Powers of the probate court for the protection of the property, which is the subject matter of a testamentary disposition, are now regulated by the specific provision contained in the Indian Succession Act. Section 247 of the Act authorizes the probate court to appoint an administrator pendentally till an executor or an administrator is appointed in the usual course. Such an administrator pendentally has all the rights, powers of a general administrator other than the rights of distribution of the estate. The administrator has to act under the immediate control and direction of the probate court. Section 269 of the Succession Act makes further provision as to how the probate court can interfere in other proceedings for protection of the property pending the grant of the debtor's administration. This section, however, does not apply if the testator is a Hindu, and
That is
in the
what
present
also
there
there.
is a
Subsection 2 is there.
yes, subsection 2
Does not apply.
does not apply. If an appointment for administrator pendentally had been made, as in this case, the probate court would have the jurisdiction to entertain that application and proceed to consider whether the facts and circumstances of the present case, such step ought to have been taken. Facts of the case in hand. Then, my lord, it's
What is the composition of the bench? I have read much earlier. so
composition of the bench. It's R.P. Mukherjee and Justice Guo. Judgment by Mr. R.P. Mukherjee. Where is AIR? Yes, 561.
560.
Yeah, AIR 51561.
Your Lordship, with regards to the point of section 247, I have clarified that there was no application for grant of administrative pendentity. With regards to the second point, I'll bring another division bench judgment of your Lordship of this High Court. Also, if your Lordship would let me show one para of the impugned order, your Lordship.
Yes. This is Atul Baladasi. Let us examine this judgment and let us see what is the other judgment of our High Court. You said there is another judgment
No,
of
no,
this
no.
court.
No, I'll bring it on the next day, your Lordship.
We stuck up to a point because she is taking a point of demurrer. Says that the application or injunction cannot be granted in a probate proceeding at all. So I just put a question, but whether in all conceivable or not conceivable, or in certain cases. She said no, it is not.
No, your Lordship.
And the division bench has the Bombay High Court said no, because notice of motion was dismissed on the ground of maintainability. A notice of motion was there filed in the original site seeking an injunction in a probate proceeding. Maintainability ground was raised, that was rejected by the single bench. The matter went to the Supreme Court, the division bench. The division bench has dismissed, upholding the order of the single bench, not maintainable. This is a judgment.
Justice Chandrachu's judgment. Sorry, I'll just check it up once. I will also check. There should be also one section, my lord, for section 253 of my lord is looking at the succession at 253. It says about Preservation of the deceased estate properties. 253. Letters of administration limited to collection.
No, this is a grant of the letters of administration to that court. It can for the purpose of protection of that property.
So
no difficulty, and that too it can be segregated. You can approach that court where the property is situated and file.
You can also
and
file.
You can also continue.
Jurisdiction.
Jurisdiction.
Territorial.
That is a different issue. It's a different one. Let us see. If I have to depart, then we'll have to depart. We have to write a reason for that. And it's an interesting point she has raised. Let us see.
I'll try to meet you.
Your Lordship, one point in the impugned order, section 269 has not been referred anywhere, Your Lordship.
Madam, first thing is cross this hurdle.
Yes.
Then if the section 269, kindly visualize the situation. You are saying that there is an existence of section 269, which debars the probate court to pass an order of injunction.
Yes.
That is what the division bench of the Bombay High Court has said. If we hold yes, cannot, then question of 269 does not arise.
Yes.
Because one can take shelter under 269(1). If we say no, it is maintainable, then whether 269 creates a bar in exercising that powers, no. That goes against you.
Whenever Your Lordship pleases.
We are ready anytime. Tomorrow come
My Lord keeps it-
prepared, but not with these kind of a judgment which has no relevance.
Okay, Your Lordship. Your Lordship then keeps it next week, Your Lordship.
Thursday, come or Wednesday.
I'm here.
Any day, Your Lordship.
Wednesday, come on Wednesday, 27th.
Great.
No, I'm here.
Yes.
I'm here. My lord will be here. My lord say.
Yes. Don't think that every time.
I think my lord will go.
No.
That's what I thought.
Great.
Yes, call the next.
Your Lordship, kindly take up item 17.
Nobody responded. We called, just passed over. We did not dismiss it.
Then it will be taken on next.
We don't know. We will go by this. Let us see. And after we finish, then we will come back. We'll come back, certainly.
I am for the appeal, Lordship. Lordship, in a suit for partition, Lordship, the plaintiffs file an application under Order 39, Rule 1 and 2. At the ad interim stage, it has been refused, holding there is no prima facie case. My only prayer is not to dispossess me. My possession should be protected. This was the prayer.
UGP may be seen the note, heard the concept for the plaintiff. But if the plaintiff injuncted, considering the facts and circumstances, balance of is not in his favor. Object of granting is not defeated by delay. So
She's obsessed with such an opportunity to be. Very much. Okay.
You wanted not to disturb your position. How
Yes.
you have proved your position?
Lordship, I have stated in my injunction application that we tried to,
Anything, any document in support of that?
we cannot provide any document, but we have lodged a GD.
Then
No, we have stated, categorically, we have stated that
will
we
not
wanted,
do. That there must be some corroborative evidence.
Lordship, what we did, Lordship, we wanted to incorporate our name in the BLLRO, but he did not do so. Thereafter, my position was disturbed. I lodged a GD, Lordship.
Why it was not
And
done?
for that reason, the BLRO has been made a party in the suit.
Why? Can you do it in view of section 54B?
No. Only the Lordship, the question is that we have stated, Lordship, we have provided the GD also.
Sections or whatever proceedings is not be done.
Yes.
Yes, Lordship.
Go, file a requisites.
But in the meantime, Lordship, my position
Was
should be,
the document of position? The mutation record is not in your favor.
no, I could not do but my predecessor interest name was recorded, Lordship.
I do not know, no documents, nothing of that kind, nothing is filed. Simply you said you are in possession. The court cannot go by the ipsit dixit of your statement at the stage of order 39 rule 1 and 2.
Lordship, kindly see the warden. There is no finding also, Lordship, to that effect.
That is a different, that's why we were talking about, that is a different one. But still, go
At
file
least,
a requisites, contest the proceedings. We will not take it.
then only Lordship can kindly make a time frame to so that it can.
What? You'll have to put in the requisites.
That we will
Have
do,
you
Lordship.
put in the requisites? You have not. In the trial court, not here.
No, that we know, Lordship, in the trial court.
So,
At once.
go and put in the requisites.
Hmm.
Sir, 17 October order and you are assailing now in 2023. When? You have filed it on December.
Yes. After reopening, it has been filed.
No, on 14 December you filed it. And none, what you were doing? No, it's nothing. So we do not intend to interfere with the impugned order. But we must make certain observations which are relevant for the purpose of recapitulation of the law, the recapitulation of the law applicable in this regard. The impugned order does not reflect any independent findings having made by the learned judge while declining to pass an ex parte ad interim order of injunction. We are conscious of the proposition of the provisions contained under order 39 rule 2. Order 39 rule 3 of the code of civil procedure, which postulate that the court before granting an injunction, direct the notice of the application to be given the given to the opposite party. But an exception is carved out in the event the court finds that the object of granting injunction would be defeated by delay. There is no fetter on the part of the court to pass an ex parte ad interim order of injunction, but the proviso attached thereto somehow controlled the exercise of such power by the court, in the sense that the court must record a reason for forming an opinion that it is a fit case where the delay would defeat the justice. Though there is no mandate provided in the said statute for recording reasons while declining to pass an ex parte ad interim order of injunction, but the importance of recording reasons in a judicial dispensation has been held to be a hallmark of imparting justice to the parties. And its dispensation was always discouraged. The court must record a reason either granting or denying the reliefs to the litigant, as he would be able to know the reasons for such decision. So apart from the same, if the reasons are recorded, it would also assist the appellate court in assessing the argument, in assessing the decision making process, and the correct marshalling of the facts and the law applicable in such given situation. We invited the next paragraph. We invited the counsel for the appellant to make a submission on the facts, and it appears to us that the relief to protect the position was sought in an application for temporary injunction, simpliciter on the basis of an averment made in the plaint. But there was no corroborative documentary evidence produced in support thereof. Though it is a suit for partition and separation of share, in such situation, without affording an opportunity to the other side to disclose the stand, more particularly whether the plaintiff is a co-sharer / co-owner or is in possession in such capacity or otherwise, it would not be appropriate and proper to pass an order of ex parte ad interim order of injunction. Apart from the same, the refusal to pass an ex parte ad interim order of injunction was passed as far back as on 17/10/2023. Considerable period of time has elapsed in the meantime, and the counsel for the appellant is unable to apprise the court whether any requisites have been put in the trial court as directed in the said order. in such view of the matter, we do not think that admitting an appeal would subserve the justice, nor we find any involvement of, nor we find that the plaintiff is entitled to get the appeal admitted. Therefore, the appeal is thus dismissed at the stage of Order 41 under Order 41, Rule 11 of the Court of Civil Proceedings. However, the dismissal of the appeal shall not prevent the appellant to take appropriate steps as directed in the impugned order.
At the time of disposing of the injunction, the learned court below should not be influenced by this.
Yeah.
I'm grateful to your lordship.
All the next. না না ওটা নয়, ওটা প্যারাগ্রাফে দেওয়া দরকার।
I am for the appeal. It is a judgment of affirmation, my lord.
Both the courts you lost.
Yes.
What do you expect from a third court?
But I leave it, lordship, my lord.
What is the certificate you have given appended to a memorandum of appeal? What do you think?
That is, I think that it will be admitted by your lordship, my lord.
Now tell me why it should be admitted.
My lord, it was, my lord, the plaintiff filed the suit for eviction.
You are defendant.
Yes, I am the defendant of the suit. Filed a suit for recovery of the possession, my lord, for building and rebuilding of the premises. But their case is that
only rebuilding and building and rebuilding,
as well as for non-payment of rent.
Not
non-payment of rent. Defaulter in payment of rent.
Default
in payment of rent.
Default
as well
and
as for
building and rebuilding.
As well as for building and rebuilding of the premises.
So only two grounds.
Only two grounds.
No other grounds.
No. Well, all 5 or 6 issues was framed. But 2 issues were gone in our favor. But in spite of that.
What are those 2 issues?
Well, that issue was below.
One must, I presume, one must be of default.
As per their contention, I am default.
That issue of default in payment of rent goes in your favor, I presume, or not?
No.
It goes against you.
Well, 2 issue which was done in my favor, my lord. That is, my lord. But you know, so kindly bear me 1 minute. Well, these 2, if your lordship kindly come to page 4.
Tell me
Page
what
4
are
of
those
the
issues?
Original suit. Page 4 of the judgment of the original suit.
What are those
Well,
issues?
that issue is the suit is the suit is maintainable in present form?
That goes against you if it is
No.
maintainable.
That goes in our favor.
Then how the suit can be decreed?
That
If
is
the suit is not maintainable in the present form.
that is why I am saying, my lord. That is why I am saying, my lord.
Maintainable.
Yes.
Then how the decree is passed?
That I don't know, my lord. And that decree was affirmed by the lower appellate court also.
What are you talking about? Show me the finding of the trial court on this.
Well, a trial court I have annexed, my lord. Trial court degree I have annexed, my lord.
Not decree, the judgment.
Judgment also annexed, my lord.
1 and 2. These issues are not pressed. These issues
Well,
are
that
not
is why
pressed.
it was done in my favor.
No, in favor of the plaintiff. What are you talking? issue number 1 and 2.
Yes. I'm sorry.
Is
I'm
the
sorry.
suit
These
maintainable?
two issues were not raised
Not
at the time
raised.
of hearing of the suit also.
And it goes in
Also,
favor
there
of the
is nothing
plaintiff.
to show that the suit is not maintainable or its plaintiff have no cause of action to file the present suit. These issues are accordingly answered in favor of the plaintiff.
So
Yes.
against you.
Yes.
So what do you say? That two issues goes in your favor? Which are the two issues went in your favor, sir?
Well, what if fellowship kindly gives some time and I can. Fellowship kindly give some time.
Sir, you have not read the brief.
I'm sorry, extremely sorry. I'm extremely sorry.
You have not
Extremely
read
sorry.
the brief.
Yes.
It is
Lord,
not a,
kindly
it
give
is-
some time. Okay.
It is not a suit simpliciter on default and the reasonable building and rebuilding. No. The suit is on the ground of default,
Yes.
violation of provisions of MOP of section 108
Old
of the
Old Act.
What old act? Here also in the new act, this provision is there.
Anyway, Your
MOP
Lordship,
of the
kindly give
Transfer
some
of
time,
Property
Your
Act,
Lordship, kindly give some
reasonable
time.
requirement, then the building and rebuilding.
Yes.
So, on four grounds, you say only two grounds.
Kindly give some time, Your Lordship. I'll try to satisfy Your Lordship.
MOP has what remains? Reasonable requirement? Nothing. My goodness, the 15 members, they were landlord. Yeah, they have to be accommodated. 15 members are there. The family of the landlord.
But the appellant, there are also some members. They have also some members. They have also 7-8 members.
Who?
The appellant, present appellant before Your Lordship. They are also.
Is it relevant in the statute? Tell me. You are bringing a concept of comparable hardship, which is not there in our act. If the landlord proves, that's enough. Whether defendant would suffer most is immaterial under our statute. There are certain statutes where they have incorporated the ground of comparable hardship, which is not here. So you can't take a grounds. Sorry, sir. Nothing is there.
Kindly give some.
Nothing is there. Nothing is there. Unnecessarily, it's a wastage of time. 15 members can't. Building and rebuilding, and there is a judgment of the Supreme Court.
Yes.
Which says that a ground of building and rebuilding coupled with the reasonable requirement is there. If after building and rebuilding, if the entire requirement which he has pleaded to be reasonable is satisfied, then you are not entitled to get back. Otherwise, in case of building and rebuilding, you are entitled to get back the position.
Yes.
But we have not seen.
I leave it, Lordship. Lordship, kindly, my Lord.
Yes, dismiss.
I'm ready.
Hey, hey, just wait. Both the courts have concurrently held that the plaintiff has been able to make out a case of eviction on the ground of violation of clauses MOP of section 108 of the Transfer of Property Act, building and rebuilding, and reasonable requirements. It is under the 56 Act.
Yes.
The plaintiff it is a specific case of the plaintiff that his family consists of 15 members. The present accommodation available to the plaintiff is too scanty and does not cater the actual needs. The advocate commissioner was appointed. The report was submitted indicating the number of indicating the accommodation available to both the parties, as well as the manner of use. Transfer and the manner of use thereof. A serious issue was raised by the defendant appellant that there is no relationship of landlord and tenant between the parties. And precisely for such defense having taken, a specific issue was framed. Stop. The court found that that there is a relationship of landlord and tenant, and then thereafter proceeded to decide whether there is any whether the grounds for eviction have been proved. Section 13 of the West Bengal Presidency Act 1956 contained the grounds on which the court can pass a decree for eviction against the tenant. It is manifest therefrom that any one ground, if proved by the landlord, is sufficient enough to grant the decree for eviction. Stop. The existing building has been found by both the courts below in such state of the situation that to meet the requirement of the plaintiff respondent, it is required to be built or rebuilt, and this plaintiff respondent has also taken such a stand. Stop. The landlord is the best judge in relation to a requirement, unless such requirement appears to be fanciful. Stop. The moment the court found that the plaintiff respondent have been able to prove the requirement to be reasonable, and further held that after building and rebuilding, it would cater the need. We do not think that there is any element of substantial question of law involved in the instant appeal. Thus, the appeal is dismissed under the heading Order 41, Rule 11 of the court.
I'm grateful.
Here for the respondent.
Respondents are 105 caveators.
Where is the appellant? 28. Mr. Oyen Mondal. Where is he? Passover?
I am for the petitioner. This is a case where Lordship suggested to have it. This is the case where Lordship suggested to go for an.
What is that?
Nothing as 3-4 weeks chance time was given to them, but nothing has yielded.
They sat.
Yes, 1 day.
Not. It's a matrimonial case.
As ex parte decree was there, then I filed the Water 9 Rule 13. That Water 9 13 was set aside.
না না 30টা আলাদা ম্যাটার।
But your lordship, I'm for the appellate. I am for the respondent. Order 9 Rule 30 in a matrimonial proceedings, appellable or revisable?
On the last occasion, your lordship was of the desirous of the judgment passed by your lordship, and this is the copy.
Reported?
Your lordship, I have obtained the unreported one that is passed in CO 1272 of 2010.
And that is reported in my lord 2015 volume 2 CHN 610.
Yellappa has been considered.
Yes, your lordship.
What is this?
It is a reported one. Mine is unreported one, your lordship.
Oh, then give me a reported one. Reported.
The judgment which was relied upon by your lordship, my lord, that also I have
Why the this is a matrimonial one. Why
এই কালকে কি নেবে গো?
সবার আগে ওখানে গিয়ে বাড়ি একটা I don't know whether you are practicing law or not, I don't know. But যদি না হয় লোয়ার কোর্টের লয়ারকে বলে এখন যে সারাটা সার্টিফাইড কপি পেলে তুলে বাড়িতে কোর্টের অফিসে একটা অ্যালিগেশন আছে বা এখানকার পর অ্যাজ ওয়েল অ্যাজ
এখানে ও তো
বার কাউন্সিল অফ
ও আচ্ছা বার কাউন্সিল, হ্যাঁ হ্যাঁ
একটা অ্যালিগেশন আন তা না হলে তোমার এই মামলা জীবন
হবে না
হবে না
আচ্ছা
সেকেন্ড তুমি ওখানে কোন একটা অ্যাপ্লিকেশন দাও ছেলেটার উপর ও ডিএনএ টেস্ট করা হবে।
এটা রিমান্ড ব্যাক করলেই তো মানে
হ্যাঁ কারণ কি এই দুটো ছাড়া তুমি
যে না
করতে পারবে না।
এই তো
আর এবারে ওদের allegation 16 থেকে তুমি বাইরে আছো 16 থেকে তোমার সাথের নয়
না না ওরা বলেছে অগস্ট অব্দি, অগস্টের পর থেকে আমরা বাইরে 16 অগস্ট আমরা 5-এ বিয়ে হয়েছে 16/5
আগস্ট থেকে বাইরে আছো তাহলে 17 থেকে তুমি এবার 9 মাস জবের বাচ্চা হলো তার থেকে 9 মাস পেছনে যাবে।
না না 9 মাস কভার করছি না, আমি যে ডেটটা মানে যে ডেটে বাচ্চাটা